Director of the American Law Program and the LLM program, in which Catholic University has cooperated with Jagiellonian University in Krakow, Poland for many years. I will be your moderator. Cristina D'Amelio Lopez, Director of Advancement in the Law School's Development and Alumni Relations Office, will now bring you greetings from the Columbus School of Law of the Catholic University of America.
Thank you. Thanks so much, Professor Wortham. Again, we were just talking about what great leadership and what a great team and vision you've all had for executing such an outstanding series of really robust and engaging programs over the past 10 webinars. I'd like to welcome today participants from the International Business and Trade Summer Law Program, the American Law Program, and the LLM in American Law, with now more than 2,000 US, Polish, and other international alumni. Pretty impressive. Professor Wortham's commitment again and her energy to foster this relationship with Jagiellonian University is really kind of stellar. Jagiellonian University, we've been discussing, is the oldest university in Poland and one of the oldest surviving universities in the world. So that really can't be understated. Fascinating. As we like to highlight in these webinars, the 30-year relationship between Catholic law, the Columbus School of Law, and Jagiellonian began with its founder, Emeritus Professor Red Ludbowski. I do this every week. Red Ludbowski. Go ahead. We're here today for the 10th webinar in the series. It's been extremely well attended and has done really well in keeping the European and American law communities connected virtually. As with each of the programs, our panelists today are really outstanding, representing the common challenges of our shared legal communities and continuing the dialogue between our schools and our communities. Thank you for being here. We really value your participation and looking forward to continuing our dialogue with you in the discussion period after the panel presentation. Thanks.
Thanks so much, Christina. So Wojciech Banczyk, coordinator of the American Law School, will now welcome you on behalf of Jagiellonian University.
Thank you, Professor Wortham. Thank you very much for those introductory statements. It's a great pleasure for me to express on behalf of the Jagiellonian University the great joy that you all joined this online meeting, showing your interest in the contemporary challenges in American and global law. My position here allows me to present the gratitude to all the persons without whom it will never be possible for this event to happen. Also, it allows me to announce a great pride for Jagiellonian University to co-organize such an interesting event, as well as many other initiatives throughout years of cooperation. This program proves that the fruitful cooperation between the Catholic University of America and Jagiellonian University survived the difficult pandemic situation and managed to convert into the usage of new technology. We are very happy that we can see one another right now, with the online meeting being some certain difficulty, and we are looking forward to in-site meetings as well. But it also allows us to meet all together here, and in the reality, it sometimes could never be possible. That's why we decided to benefit from the COVID situation and from the development of online tools to develop a new initiative in the absence of traditional in-site meetings. This way, we can learn and meet together also right now. We are very happy to observe the huge popularity of the webinar series, which for months keep gathering as huge audience as nearly 200 participants during each webinar series. We are very happy to have you all here, and we are very proud that such a great group of us gathered here despite evening time. At the same time, we hope that sooner or later we will all meet in person during our programs or alumni events.
Thank you. This webinar series is a team effort, starting with the support of Dean Stephen Payne of Catholic University and Dean Jerzy Piszyliński Dean of the Faculty of Law and Administration at Jagiellonian University. It draws on the leadership and staff of the Jagiellonian Center for Foreign Law School Cooperation, often referred to by its Polish acronym OXPO, and the Catholic University Central and the Law School's Development and Alumni Relations and Communications offices, as well as the help from our LLM coordinators and LLM graduates, Gaspar Cote and Ruth Bartosi. Please check the website for information on the remaining March webinars. The URL is in the chat. You can also there find the links for the recordings for the recent webinars. On March 3rd, we're pleased that CUA Professor Kara Drynan will discuss the ideas developed in her Oxford University Press book, The War on Kids: How American Juvenile Justice Lost Its Way. We're honored that our commenter will be Jagiellonian's own chair of criminal law and Polish Supreme Court Justice, Władimir Wróbel. Our March 24th webinar features LLM graduate Gaspar Cote talking about the European Union's new Sustainable Development Regulation, which will impact not only Europe, but most of those in the United States who are involved in funds management. Our commenter is distinguished CUA JD graduate Chris Concannon, who is President and Chief Operating Officer of Market Access, a global electronic trading platform for institutional investors and dealers around the world. The 4 spring session webinar registration links will be available shortly. Like our March 3rd webinar, 2 of those will touch on criminal law and human rights. On April 14th, Katarzyna Wolska-Wrona will talk about international approaches to combating gender-based violence with JD alumni Judge Diane Kiesel commenting. On April 27th, CUA Professor Mary Graw-Leary's webinar will be #MeToo and #Black Lives Matter, conflicting objectives or opportunities for advancement and shared priorities. Our commenter will be International Business and Trade Summer Law Program and distinguished Polish academic Alexander Kustra-Rogatka. On May 12th, Regina Jefferson talks about the application of international human rights policy to the United States approach to retirement savings, with comments from another distinguished Polish academic, also an alum of our summer program, Elżbieta Karska. As previously mentioned, Gaspar Cote's March 24th webinar concerns funds management in the EU's Sustainable Development Regulation. Our final webinar on June 2nd addresses additional developments in the European Union and the United States on investment funds regulation. As announced in the last webinar, we've now determined that visa, border, and health rules in place will allow LLM students to enter the US in May for the CUA summer session component. And we are starting the visa process for those coming this summer. If there are any of you or people you know who are American Law Program graduates who were interested in joining the LLM and coming to DC this summer, that would still be possible if we commence the process right away. So if that is something you're interested in, please email me right away. My email is in the chat. So unfortunately, we announced in last webinar that we are suspending the summer program, both the CUA summer program in Krakow and our program in Rome for this summer again. We felt the health situation was still just too uncertain to go forward with programs in May and June. So we are looking forward to resuming that program in 2022. We are cautiously optimistic that we will be able to go forward with the live American Law Program in next academic year. And so we will be providing you more information about that as the webinars progress. So Heidi, you can go ahead and put your slides up so they'll be ready. And in the meantime, I'm going to talk for a minute or so about how we organize the webinars and introduce our speaker and our commenter. I expect most of you have used Zoom or a similar video conferencing platform before, so you know about typing questions in the chat. I'll be taking the questions from the chat and posing them to our speakers. You can type your question there directly, or if you prefer, you can click where it now says everyone and find my name, or Wojciech Banczyk's name, or Gaspar Cote's name, and type those privately, and they can pose your question for you. You can also use that link if you see a friend or a colleague who's on by looking at the names on the screen or looking at the participant list. You can send a private email saying hello if you would like. Unfortunately, the registration software does not recognize some Polish characters, so we apologize if your name shows with a question mark or some odd character. When you register, if you just use English characters, we'll avoid that. So Professor Schooner will speak for about 20 minutes. She'll be followed by a comment from Michal Bobrzynski, who will also lead off the question and answer period. As I mentioned before, please type your questions in chat as you think of them, or to Wojciech Banczyk or Gasper Koch. The session is being recorded, and the 60-minute webinar will be posted on CUA's YouTube channel. The series website also links to the recordings. At the end of 60 minutes, I will close the formal webinar and the recording. Professor Schooner and Mr. Bobrzynski graciously have agreed to stay on for another 30 minutes. So I encourage you to stay on for questions and answers and discussion. And usually most of you are able to join us, so that's great. In the chat, you will now see links to bios for Professor Schooner and Mr. Bobrzynski. I will just briefly give some highlights from those. Professor Schooner's writing focuses on challenges in regulating the financial services industry. She co-authored Global Bank Regulation Principles and Policies. She teaches courses in regulating financial institutions, corporations, contracts, and commercial law. Prior to joining the faculty, she worked for the US Securities and Exchange Commission, a bank holding company, and in private practice. Commenter Michal Bobrzynski is a partner in the Warsaw office of Greenberg Traurig, an international firm with more than 2,200 attorneys in 40 offices in the United States, Europe, Latin America, Asia, and the Middle East. Mr. Bobrzynski advises financial institutions on regulatory and transactional matters, as well as domestic and international companies on corporate matters, bankruptcy and restructuring, mergers and acquisitions, and private equity transactions. He received an LLM degree from Harvard Law School in 2009 and his magister degree from Jagiellonian in 2005. He is a member of the New York Bar and the Krakow Attorney at Law Bar. Many of you will remember him from his years as a research and teaching assistant in Jagiellonian and as coordinator of the American Law Program from 2010 through 2014. We now turn to Professor Schooner. Please remember to type in your questions. After she finishes, we will then turn to our commenter, who will also lead off with the questioning. So, Professor Schooner.
Thank you, Leah, and thank you so much for putting together this wonderful program. Good afternoon and good evening. I am very happy to get this chance to share with you the challenges to the financial system in this historic moment of the global pandemic. I am going to, hold on. There we go. I am going to assume that the audience is not full of experts and that for many of you, this is sort of new ground. So I'm going to start with an overview of why we regulate the financial sector, talk about how regulation of the financial sector was affected by the global financial crisis in 2008, and then finally focus on whether or not those reforms prepared the banking system for the pandemic. So let me just start by talking quickly about what we mean by the financial sector, at least from the vantage point of the United States. The financial sector involves lots of different types of firms, and this slide just shows you the various categories. Let me say that in my remarks, I'm really focusing on that first bullet, the US depository institutions or banks. And they obviously represent a very large portion of the financial sector, but the US is known for the fact that our financial sector is very diverse. But my specialty really focuses on banks. And in the United States, as in many countries, the banking sector is highly concentrated and focused on a couple of very large institutions. And so, you see these very familiar names here. These are very large institutions in terms of assets. That is the way in the financial sector we tend to look at size. So these firms all have trillions in assets. Other sectors aren't necessarily measured in terms of size. So if we compared, for example, Amazon doesn't have anywhere near the asset size of a JP Morgan, and yet we still would think of Amazon as a very large tech company. But this is the way we look at size in the banking sector. So let's talk for a moment about why we regulate the financial sector, or in particular banks. There are really two fundamental reasons that we regulate financial institutions. One is to protect the economy from the systemic collapse of the financial system. Because the financial system supports the entire economy, it's important that the financial system is always there, ready, willing, and able to support the economy. So that is really the focus of this talk today, is that idea of protecting the financial system from systemic collapse. But I do want to just mention that another very important aspect of financial institution regulation is the protection of investors and consumers. So my pictures on the slide are, one is from the movie from Michael Lewis's famous book, The Big Short, which really does a great job of showing some very interesting aspects of the financial collapse in 2008. And then just a reference to a great mis-selling scandal of Wells Fargo in the United States a few years ago, where they were opening up fake accounts for customers. And so just to give you that contrast of the different goals of financial regulation. So again, at the top of my slide, protecting the system from systemic collapse. Why are we doing that? We do that with respect to financial institutions for two reasons. First, financial institutions are notoriously fragile. So what do I mean by fragile? I mean that financial institutions typically have a mismatch between their assets and their liabilities. And let me tell you what I mean by that. A typical bank will hold assets that have a very long maturity. If you think of a mortgage or a long-term bond, it's not going to be paid back in full for many, many years. But banks have debts that are due on demand. Again, think of the typical bank deposit, where a depositor can go in and withdraw all their funds at any time on demand. This mismatch between the maturity of the assets and maturity of the liabilities makes financial institutions fragile, or we could think of susceptible to insolvency. And that is the nature of the financial institution, makes it such that regulators are concerned that they remain solvent and remain available to servicing the economy. Let me just say one other thing before I move off of the reasons. Another reason why regulating the financial system is so important is that banks and other financial institutions are highly interconnected. So if a bad thing happens to Wells Fargo, for example, the chances are that impact will be felt far beyond simply that firm and will be felt by other financial institutions. Let me also just show you this slide. It's one of my favorites, comes from the Government Accountability Office, just to show you that financial regulation in the United States is notoriously complex. This slide up at the top, all those purple boxes show all the different regulators in the US. This is very distinctive of the US. There isn't any other country that has such a complicated system for financial regulation. We're really not gonna talk a lot about that today, but I did want to just put that in your mind as a backdrop that does make the United States quite distinctive around the world. So moving on to just a little reminder of history with regard to the financial crisis, which really started in the US with a extreme growth in prices in the housing sector, and creating what is typically called a bubble, an asset bubble. That bubble burst starting around 2006, 2007, and that triggered massive foreclosures and drops in the value of certain assets that were tied to the housing market. Probably most controversial and memorable from that period from a regulatory standpoint is that the government rescued many financial institutions, and those financial institutions that were rescued by the government were considered to, in other words, the government believed that it did not have the option of allowing those financial institutions to go into bankruptcy, and therefore supported them. And that was, we can talk about a little bit later, pretty controversial. Although seen by many as necessary, still controversial. The economic loss from the 2008 financial crisis was significant, and there are aspects of those losses that we still feel in the economy today. The congressional response in 2010 to the financial crisis was to pass a comprehensive law called the Dodd-Frank Act. And it did a lot of things. I just want to focus on a couple of those things here so that we can see and consider whether the reform that was put in place as a result of the financial crisis prepared the financial system in the United States for the current pandemic. So Dodd-Frank, probably most importantly, put in place a more rigorous system of regulation and supervision for very large banks. And I've got to get a little bit technical for a moment and talk about capital requirements, because this is really a fundamental feature of how we regulate financial institutions, both in the United States and around the world. So let me talk for a minute about what I mean by higher capital requirements. So all firms finance their operations with a mix of both debt, they borrow money, and retained earnings or shareholder contributions. So firms typically use a mix of debt and equity to finance their operations. Banks, for various reasons, tend to finance their operations with a lot more debt than equity. So they are, by their nature, fragile because of this. Another way of saying this is that they are highly leveraged. They hold a lot of debt as compared to their assets. So bank regulation limits the extent to which banks can use debt to finance their operations. They still use a lot of debt, but capital regulation puts a cap on that. Dodd-Frank required banks over a period of time to increase their capital, which is another way of saying decrease the amount of debt that they hold on their books. And that was particularly with respect to large banks. Capital requirements were increased for all banks, but particularly with respect to large banks. The Dodd-Frank Act also created a new regulator in the United States. It's sort of unusually configured, and we can talk about it if anyone's interested, but it's the Financial Stability Oversight Council. We call it the FSOC. And it was created to monitor systemic risk throughout the financial system. Prior to Dodd-Frank, the focus was much more only on banks. And as we talked about a moment ago, the financial sector isn't only made up out of banks, it also includes other types of firms, securities firms, insurance companies, mutual funds, et cetera. And so the FSOC was created to monitor and deal with systemic risk throughout the financial sector. There were also in Dodd-Frank provisions put in that were intended to eliminate this too big to fail kind of phenomenon. The idea was that the public was not happy with having the government step in and rescue large financial institutions. And so the law put in place certain provisions that were meant to eliminate that particular phenomenon from happening. Similarly, there was some concern about our central bank, the Federal Reserve, and their use of their emergency lending authority, which they used extensively during the crisis and afterwards. So there were some restrictions put on the Federal Reserve's lending authority. So now we're going to try to fast forward up to 2019 to 2020, 2021, and think about the impact of a non-financial crisis on the financial system. So the financial crisis of 2008 was a perfect example of how you deal with a financial crisis that financial system crisis that arises from within the financial system. COVID-19 obviously is a perfect example of how financial institutions can be affected from events that originate outside of the financial system. It's probably not a surprise that in the United States, Congress responded dramatically to the outbreak of COVID in terms of providing all sorts of funding to support banks, households, small businesses, just many, many different types of programs to try to address the unrest that was brought about by the pandemic. I'll just note one of the points on this slide because I'll come back to it later. With respect to the involvement of banks in the COVID response, Congress passed a program called the Paycheck Protection Program, which was a program that was put into place to assist largely small businesses with the specific intent of supporting those businesses so that they would not lay off their employees, so that we would avoid a certain amount of unemployment. That program was administered by our Small Business Administration, but distributed by banks. And I'll come back and talk about the Paycheck Protection Program a little bit later. So the Federal Reserve also robustly responded to COVID. It has provided financial support in many, many different ways, both to the financial system and more directly to non-banks and households. So we've really seen an unprecedented government response in the United States to COVID. So how did Dodd-Frank prepare the financial system, specifically banks, for the pandemic? I think we can say that the good news is that at the moment, banks were better capitalized prior to COVID. In other words, they had relatively less debt than they had during the financial crisis. And therefore, they were stronger and a little bit better able to withstand the stresses that were placed on financial institutions with the onset of the pandemic. So banks went into the pandemic because of Dodd-Frank better capitalized, and therefore they, the financial system shows some stability in that way. The Federal Reserve typically and periodically performs what are called stress tests on large financial institutions. It's almost like a fire drill, where they put the bank through certain hypothetical scenarios to see whether the bank can withstand certain stresses. And at least the stress tests that have been performed to date, banks remain strongly capitalized, even assuming some fairly dire scenarios. And we'll talk a little bit more about that in a moment. I would say that the one problem with assessing the health of the financial system right now is that there remains significant uncertainty. The financial sector has certainly benefited both directly and indirectly from all that intervention that I talked about a moment ago, both congressional intervention and intervention from the Fed. And so it's sort of hard to know how strong the financial sector is on its own in the absence of all that intervention. And it's also hard to know whether the health of the financial system will stay the way it is right now when the time horizon of the sort of end of the pandemic and return to normal life is certainly uncertain. I also just want to mention, for those that might be interested, I'm really focusing in my remarks on banks, but a big part of the financial sector are the so-called shadow banks, banks that financial institutions, for example, like money market mutual funds, that act very much like banks, but are not actually depository institutions. Early in the pandemic, the shadow banking sector actually showed quite a bit of vulnerability. And that does sort of have us question whether this new agency, the FSOC, really has been able to provide some safety measures to prevent fragility in the overall financial sector. So just one last point on, I'm not going to burden you too much with these charts, but I just wanted to point out some research done by the New York Fed about the banking system. And essentially what these charts show is that while banks remain adequately capitalized, the capital position of banks is showing some deterioration. In other words, banks are beginning to show more reliance on debt compared to their assets than their retained earnings or shareholder equity. So that is a place of weakness, not that banks are undercapitalized at the moment, but their capital levels have decreased. The flip side of that is that a bank's liquidity right now is quite strong. What do I mean by liquidity? Banks are holding quite a bit of their assets in highly liquid instruments like cash and treasury bonds, et cetera. In other words, assets that can be converted into cash very, very quickly. That's good for banks in terms of being able to deal with sudden demands on their assets, but it also has some downside, which I'll talk about in the next slide. So let me just end, because I see I'm right at the end of my time, with a couple of concluding observations about banks in this, US banks in this pandemic. I want to say that I think it's very interesting from a political standpoint to see the difference in tone in considering the support that the government has given to the financial system in this pandemic as opposed to during the financial crisis. In other words, I think in terms of the way that the public views government intervention, probably does matter where the stress is coming from. When back in 2008, when it appeared that the financial system was the cause of its own problems, there was a lot of public outcry with respect to support of the financial system. Whereas I've seen an absence of that kind of outcry today when the stress is coming from the outside. Let me also say that I find it somewhat troubling that the Federal Reserve has continued to allow banks to distribute some of their cash in the form of share buybacks and dividend payments during this time of stress. The Federal Reserve has limited that kind of distribution of dividends, but they've allowed it to a certain degree, and they even loosened those requirements very recently. This seems to me to be potentially problematic, given that we don't know the timeline of the crisis, and this is probably the time to be saving cash rather than distributing it. We'll see soon how banks are able to withstand the Fed's next stress test. As I mentioned, it's sort of like a fire drill where the Fed puts the banks through some very dire scenarios. They have passed so far. We'll see. The next stress test is going to be even more rigorous, and we'll see how the banks do. As I mentioned in the last slide, banks have been increasing their liquidity, which is a fancy way of saying they are holding more cash and liquid bonds in their asset portfolios. That has a consequence. That means that banks are not lending as much. And in fact, the 25 largest banks have significantly decreased their loans in the last year. This is not a good thing. Banks are supposed to be available to provide credit to the economy when the economy is weak. And so this might be good for the preservation of individual institutions, but it's not necessarily a sign of banks performing that function that they are created, that they are established to provide. And then finally, I mentioned this Paycheck Protection Act program that Congress set up to distribute funds. They are loans that can be converted to grants to small businesses. Unfortunately, early on in the program, Black-owned businesses and other minority businesses were disadvantaged in terms of the early distribution of funds from that program. And I just want to end with this thought that crises tend to exacerbate effects on those that are the weakest in the economy. And certainly the PPP program is evidence of that those businesses that went in to the crisis with relative weakness, which is definitely true with in the United States with minority-owned businesses, unfortunately suffered a disadvantage at least early on in the program. And we're hoping that some of that disadvantage has been alleviated with later iterations of the program. And with that, I will end and look forward to your questions.
Great. Thank you so much, Heidi. So Mr. Bobrzynski has a few slides too, so he's going to put them on and we'll now hear from him.
Yes, just yeah. Hopefully that works and you can see part of my screen. Thank you very much. Thank you very much, Leah, for inviting me to this webinar series, and thank you very much, Professor Schooner, for this excellent introduction to the situation of the U.S. lending institutions. I thought that I might shed a couple of thoughts concerning Poland, where we are in Poland as of today, being some people say in the middle, the others claim that we are at the end of nearing the end of the pandemic, and what are the prospects for the Polish financial institutions going forward. So, by way of saying some obvious things, we do need banks for the economy to prospect. Banks are important sources of funding, and they are important also gatekeepers of the economy, with their role consisting to a great extent also in screening various projects proposed by the business and sorting out those projects that seem to offer most prospects of success and declining to finance the projects which do not offer many chances of success in the future. So by saying something obvious, sources of capital are different. Businesses are financed via debt, they are financed via equity. The question is how the situation looks in Poland as of today. So apologize for the slides being in Polish. They were taken literally from the very recent report prepared by the Civic Development Forum, which summarizes the situation of the Polish banking sector at the outbreak of this year. Poland, compared to the other economies, in particular the United States, is heavily dependent on banks. We have approximately twice as large in the banking sector as the equity sector. If you look at the figures for the United States here on the left, the banking sector in the United States is much smaller compared to the equity, to the stock market financing. In terms of numbers, the Polish banking sector is approximately or considers the half of the Polish gross domestic product each year. Similar as in the United States, which is actually a good thing from the systemic point of view, because in terms of if there were a crisis in the banking sector, then hopefully we would not be in the same situation as Ireland or Iceland or Cyprus in 2008, which required heavy government subsidies to rescue their own banks. However, there are a couple of very worrying trends happening in Poland or taking place in the Polish banking sector as of today, which cast some shadows as to the direction where the Polish banking sector is heading. The first of one is this is a corporate finance term which shows what is the profitability of the shareholders investing in the Polish banking sector. So starting from 2015, the rate on equity, which is the one of the major or measurements of the profitability of an investment in the Polish sector, is declining. So up to 2015, if you invested in a bank, probably your rate of return would be higher compared to similar investment in another industry. From 2015 onwards, the rate of return is falling down. What is the consequence for that? The consequence is that it's that running a bank in Poland is becoming much more and more costly for the owners. The consequence, the first and foremost impact of that is that many of the non-Polish banking groups are pulling out from Poland. Over the past couple of years, you can see a couple of major players such as General Electric, Raiffeisen, Deutsche Bank, KBC, or Nordea pulling out from this market. And the reason to limit the investment in Poland was driven to a large extent by the falling rate of return on their equity investment. The second consequence of that is that it's, especially for a publicly listed bank, it is very, very difficult to raise new capital on a stock market, because the investors simply have better opportunities to invest their money, which yield like better returns in the future. This decline in the profitability of the banks from the shareholders' perspective is to a large extent driven by the various public levies imposed on the banks. This clearly correlates with introduction of the banking levy in 2015 by the recent Polish government, which actually takes the majority of the profits made by the banks and has some various negative adverse effects in terms of incentives that I will discuss shortly. The other negative trend, so to say, from the bank's perspective, similar in Poland as in the United States, are very low interest rates imposed by the central bank, which are on one hand beneficial for the borrowers, because you can simply borrow it, the money is cheaper and you can borrow at a lower rate. But if you compare that with the expected rate of return on the equity and with the levies that the banks have to pay in Poland to the public, to the state budget, it is becoming more and more difficult for banks to run profitable operations, so that the costs that they are bearing are covered by the profits they make from the lending operations. The other negative issue connected with the bank levy is that it is levied on the assets of the bank. That means the more assets the bank has, the more money it has to pay to the state budget. But there is one important exemption from the calculation of the tax, which are state bonds. So whenever the Polish government issues bonds to finance its debt and finance its operations, and such bonds are acquired by a bank, they are exempted from the bank tax, which in consequence means that it's sometimes more often than not more profitable for the Polish banks to invest in the bonds issued by the state government instead of extending loans and credits to private businesses. The next point, which is a big uncertainty as of today, is the amount of losses caused by the COVID pandemic. The banks are not really able to ascertain how much or how big reserves or provisions they should create for the losses created by COVID. The reason is very simple. In the last year, 2020, the recognition of loss was deferred or delayed by artificial means, simply by suspending certain accounting rules, in particular IAS number 9, which International Accounting Standard number 9, which deals with how the banks are supposed to recognize the losses on their balance sheet. Those rules were temporarily suspended, so that the banks could live under the assumption that their borrower is solvent without really investigating its actual current financial standing. It is, however, assumed that, at least by the Polish Central Bank, that the losses will not be so grave for the past year, but this year, like the sector in total, will suffer a loss of approximately 3 billion zloty. So the expectation of the Polish Central Bank is that the Polish banks, that the results of the Polish banks will be negative this year, in particular because of the COVID write-offs that they will have to create in 2021. So as you can imagine, we are still in front of the expected big wave of bankruptcies among the businesses. The reason for those bankruptcies being delayed was primarily driven by the huge government spending last year, which was offered to the businesses without examination of their creditworthiness and without examination of the merits of their business case to receive support. The businesses thrived on that lending. However, they might become some sort of zombie firms this year and might not be able to withstand the economic conditions in this year. So we expect like a wave of bankruptcies before of us. So that will definitely have a negative impact on the financial situation of the bank and the losses that they have to suffer. Finally, we have the last piece, important piece in Poland, which is specific for Poland as a jurisdiction, which is the issue of the Swiss-denominated home mortgages. As you probably all know, the issue is high on the agenda of the Polish judiciary right now. By the end of March, the Polish Supreme Court should issue a ruling or decision what should be the consequences of using abusive clauses in a loan contract denominated to a foreign currency. The tendency, however, as of today in the Polish courts is to find such loans to be null and void, with the consequence of with the financial consequences for the banks that are increasingly creating provisions and write-offs for those loans, which might in total, in the worst case scenario, amount to their overall own capitals. So depending on the outcome of the litigation and the position of the Polish Supreme Court and whether it is finally, whether it will turn out that this matter would be resolved by the government or by the parliament in way of a statutory intervention, the risk is that the own capitals of the Polish banks, regulatory capitals of the Polish banks, might be to a great extent eaten or consumed by the losses created by the Swiss franc mortgages portfolio and by the COVID-caused losses from the customers, who suffered a decline in revenue because of the COVID pandemic. Taking into account the overall economic environment consisting in low interest rates, high public charges in form of the bank levy, and the difficulty to raise capital on a stock exchange because of the limited availability of funds to the banks caused by the fact that other investments, other businesses are simply much more profitable for the shareholders. This is a recipe for a crisis going forward, and it remains to be seen how the things will develop over the course of next months. Yeah, we should of course hope for the best, prepare for the worst. The starting point in Poland, as compared to us in the United States, is very good. The banks are overly capitalized, but the risks are grave, and we have to be very wary about the overall economic development and those specific issues related to COVID and Swiss franc mortgages portfolio that might have adverse negative impact on the banking sector as a whole, and because of that, also on the economy at large.
Thanks so much, Michal. And you have a question to lead off our questions?
Yeah, so probably, you know, the one thing that I have always on my mind when I discuss the regulation of the financial institutions is to what extent the regulation has become like overly complicated. I must admit, I'm a lawyer in private practice. We're specializing in the regulation of financial institutions. And I often personally get lost and have troubles to identify the appropriate set of rules that should answer the question I have at hand. So probably maybe the first question, just to kick off our discussion to Professor Schooner, is to what extent you think that all the legal requirements that you described in your slides that were implemented or put in place after the 2008 crisis are simply overly complicated, and to what extent like a simpler approach to financial institutions, to the regulation of financial institutions, would do the job, or would serve the same purpose without imposing the additional complexity and transactional costs that are related simply with understanding what the law says.
Yeah, I love this question because it is so important to the actual practice of advising regulated institutions. I believe that the current rules are too complicated, more complicated than necessary. So I talked about capital briefly, and you know, capital regulations began only fairly recently to be an important part of the way financial institutions are regulated, sort of in the 80s. It began through a cooperative arrangement between the US and the United Kingdom. And at that time, there was one ratio that banks had to comply with. And today, not only are there dozens of ratios, there are complex ways of calculating. And I'm just using this as one example. I think and so I really do think that the regulation has become overly complex. The defense of it is that the institutions are very complex. And at least in the United States, and I'd be interested to know if this is true in Poland, in the United States, the industry is very different. So I really focused my comments on the large banks, the very largest institutions. But there are many thousands of just banking institutions in the United States, and many of them are quite different, not just in terms of size, but in terms of their business model. And so the argument that often really comes from the client, comes from the industry, is that, you know, when you impose this one rule, well, that rule might be important for the big institution, but it's not appropriate for the small institution. You mentioned home mortgages. There was, right after the financial crisis, there was a lot of discussion about how the mortgage markets are regulated. And the smaller institutions did not like the way the Dodd-Frank rules were treating mortgage loans and the mortgage lending business, because they didn't think that it was consistent with their business model and was really written more for the large financial institutions. So So the problem is that the simpler route doesn't necessarily always even satisfy the industry, right? The industry might say, we want simpler rules, but then if you put in simpler rules, then they say, no, we want it tailored to our particular institution. So as an academic, I'd like to see simpler rules because I think then we can measure them better. There's often less opportunity for arbitrage for parties to sort of work around the rules. But you end up with a lot of pushback from the industry on that, who want rules that are specifically tailored to them. And so I should mention with respect to that during the Trump administration, there was legislation that was passed that really addressed that concern, that tried to provide some relief to certain institutions. They tend to be smaller institutions that felt like some of the rules under Dodd-Frank simply should not be applicable to them. And so there is this sort of push and pull, I think.
Great, thanks. So we have 2 questions in the chat thus far. So everyone can be thinking about your questions. And when we move to our last informal half hour, there's the opportunity, if I'm sure Heidi and me have some questions for each other, which we can always if we have time as well. So I think I'm going to take time for the question from Marcin Klesiak, who's one of our LM students. And so I'm going to ask his question, which I think will then finish off our 60-minute recorded, and then we'll turn off the recording and just continue on with another question in the chat. And I'm sure there are additional questions we'll start to see as well. So Martin's question was, Professor Schooner, is lowering or increasing interest rates by the government an important tool to control the liquidity that banks have?
So I'm somewhat reluctant to answer that question because it's really a question for an economist, not for a lawyer. But certainly interest rates are an important part of this equation. I think the problem right now is that we went into the COVID era with very low interest rates already. So to the extent that typically the central bank will lower interest rates to spur the economy and spur lending, that there wasn't really much room available in terms of taking that route. I've seen, again, I'm not an economist, so I'm somewhat reluctant to delve into this area, but I've seen some rumblings about the Fed raising longer term interest rates to provide more incentive for lending, because of course, while cheap money is in some ways great, it also means that there's a very small spread so that banks can't make as much money on lending, and that can affect lending markets.
Thanks. All right, we're within 2 minutes of our end of recording, so I think I'm just going to make a couple final announcements, and then we'll end the recording and just continue on. We have a couple questions in the chat already, and we'll continue on with the discussion in the last half hour. So thanks to any of you who have to leave us. I hope most people can stay on. There was a little confusion, just to let you know, most of our webinars are on Wednesdays. The one next week is on Tuesday. It's on Tuesday, March 2nd, and we hope that you will join us. That's the one with Professor Drinan and Professor Vrubel. So we hope we will see you then. Again, please, if any of your American Law Program graduates who are thinking you really would like to come to DC this summer, please be in touch with me right away. We hope that we will be having our American Law Program at least close to normal by October, and we hope to see many of you in that. So we're now going to end the recording and just continue on. So I'll be asking a question from our